Well, good morning, everyone, and welcome back to AJ111 Criminal Procedure. My name is Tony Farrar, and of course, I am your instructor for this semester. This morning's lecture is going to cover Chapter 8, where we are going to take a closer look at interrogations and confessions. And more than likely, this will be a two-parter, which several of the chapters this semester are going to be pretty much because of the amount of content that we need to cover, because there is quite a bit of information. So with that said, let's go ahead and jump right into our lecture for this morning. Now, to start off with, I have a couple of videos that you can watch, two different interrogations, one of an adult and one of a juvenile, just to kind of give you a little bit of context if you want to watch them. You don't have to. And to show you the different variations on how interrogations may not be done appropriately, if you will. So that'll kind of just get your juices flowing and get you going. And then, of course, we watch television all the time, and you have your favorite program, and we watch and we think we learn how interrogations are supposed to be done, but in reality, we don't really know what the role of confessions are in the criminal justice process, and sometimes we only think or we learn from TV. And unfortunately, while TV is okay, it's not necessarily 100% factual. So a couple of quick terms which are really important for us to understand before we move forward with this lecture, and that's the difference between a couple of these different types of meanings. So typically there are three terms that you need to keep in mind as we go through this chapter. The first would be admissions. So kind of asking you what is an admission by definition? What do you think it might be? And I'll give you kind of a second to think about that. So an admission is where an individual admits a fact that tends to establish guilt, but he's not really maybe admitting to committing the crime. So here, an example would be, I was present at the scene of a shooting. That is typically an admission. Now, an admission when combined with other facts may actually help lead to a criminal conviction, but admission by definition is a fact that tends to establish guilt, but doesn't really prove it yet, such as someone's presence at, let's say, the scene of a shooting. Next would be a confession. So what would be a confession? And I think that would, we're all kind of, if an admission is only to a certain level, a confession might actually be at kind of a higher level, if you will. So this is where when an individual actually acknowledges the commission of a crime in response to police questioning, or may voluntarily approach the police and say something or confess to something. So again, admission is a fact that tends to establish guilt. A confession is where somebody actually acknowledges the commission of a crime in response to questioning, or they voluntarily confess to something by approaching the police and giving them that information. Well, now that we've covered those two, is there something left? Well, there is a statement, and this is a oral or written declaration to the police in which an individual may profess or assert their innocence. So you can see there's a little bit of difference between those three terms, and it's really important that you know those three terms as we kind of get going this morning. So with that being said, let's look at a very important case, Colorado versus Conley, 1986. I have a link there for you to look at. And when we talk about admissions and confessions, here's kind of a case that'll get you thinking. So on August 18th, 1983, Officer Anderson for Denver PD was in uniform, working in an off-duty capacity in downtown Denver, and a lot of law enforcement officers might work some off-duty assignments. And an individual by the name of Francis Conley approached Anderson, and without any prompting whatsoever, stated that he had murdered someone and he wanted to talk a little bit more about it. Now imagine if that was you. I mean, it's super interesting, but look at it or think about it more on the aspect of is what this person says, can I use it type thing. So understandably at first confused by this, Anderson then asked Conley several questions, and Conley told Anderson that in the past he had been a patient in several mental hospitals. To Anderson, Conley seemed somewhat normal and fully able to understand the nature of his acts. So at that point, a homicide detective took over the case and at that point read Conley his rights, his Miranda rights, and we'll learn more about those a little bit later. And he was also able to confirm later that there was in fact a homicide victim that matched the story that Conley was telling. So, I mean, how are you so far? How you doing on whether or not you think there's any legal issues or something like that? So, let's kind of keep going. So, Conley took the detective and the officer to the alleged crime scene. And throughout the investigation, there was really no indication that Conley was suffering from any type of mental illness. And later, during the interview by the public defender, Conley became disoriented and began to hear voices. And subsequently, at the preliminary hearing, Conley ended up moving, his attorney moved to suppress all of the statements. And so now what? So we have this cool story. We have an off-duty officer working an assignment. Somebody walks up to him, tells him that he did something, starts talking about it. The off-duty officer turns it over to an on-duty detective. They end up going to the crime scene. The stories and stuff like that kind of match. And then when it ends up going to court and we go to the preliminary hearing, the defense basically says, you know, if we kind of back up here, we want to suppress all the statements. Assuming that, of course, because Conley became disoriented. So now what? What do we do? Or can we really do anything? So Dr. Jeffrey Messner, a psychiatrist employed by a state hospital, testified that the respondent in this case, which was the suspect who admitted stuff, was suffering from chronic schizophrenia and was psychotic the day before the actual confession. And the doctor also testified that in his expert opinion, that this same individual was suffering from what they call command hallucinations, which interfered with his ability to make rational choices, meaning like, if you did something like that, would it be rational for you to just go up and tell an officer that you did that? So the doctor is kind of inferring here that these hallucinations interfered with this person's ability to make rational choices, like not saying anything, etc. So what are some of the issues that you see in this particular case? And I hope you've kind of been following along. Were the statements voluntary? Because these are all things that are going to come into play as we look at this chapter. Were the statements involuntary? Interesting. Does it matter that the suspect might have a mental illness? Like, who cares? He still gave us info. So can we use it? The officers here, they didn't coerce the individual. So should that be enough to show that the statement was voluntary because there was no coercion? So think about that a little bit more, and if we have time, we'll come back to the case and we'll take a look at it because I think you'll find it super interesting. At least I really do. And again, we'll if we have time, we'll go over it. Another case that's actually very, very interesting would be the study of the Menendez trial. And these are two brothers that basically killed their parents, extreme brutally, if you will, and later claimed that it was because of abuse and things like that. But there were a lot of statements made and confession tapes from the psychologist that they spoke to, etc. And it's a really cool case. So if you have time, take a peek at that. So anyway, let's go ahead and kind of dive into what we're going to talk about today. So the writings of the late Professor Fred Inbow of Northwestern University continue to have a significant influence on the tactics and strategy of police investigations. Professor Inbow argued that throughout his career, detective novels and films and TV had misled the public into believing that police solve most crimes by relying on scientific evidence or eyewitness identifications. And the question really kind of comes to mind, is that really true? He pointed out that in a significant number of cases, this type of scientific evidence is not available. And therefore, law enforcement is kind of stuck with or forced to focus on getting confessions. So again, if we look at kind of a quick example, you discover the body of a dead female who appears to have been the victim of a criminal assault. She's been killed, and there's no indication of forced entry into her home, and the police investigation fails to yield any DNA or fingerprints or fibers or witnesses or anything else. And police question everyone who may have had a motive to kill the victim, including the victim's former angry husband and her brother-in-law, who had quite a bit of gambling debt and owed the victim a lot of money, so a couple of potentials. So they question everybody, and still nothing. So now what? What is it that we're supposed to do? So again, we kind of go back to what Professor Inbow was talking about, that in a significant number of cases, more than you actually think, all of this cool evidence is not found. And now we are forced to rely on a confession. So the brother-in-law eventually, in this case, tires under skillful police questioning and finally confesses. And honestly, without the confession, we would not have been able to get any of that information at all, right? So this example really illustrates three important points concerning the importance of confessions. Number one, that many criminal cases can only be solved through confessions or information that is obtained from other people. Number two, suspects often will not admit their guilt unless they are subjected to lengthy interrogations. And think of even if you have kids, think of your kid. And I raised 5 kids, so this is a great example for me. And if something was broken or something, something like that, and you kind of call them in, or you could do it one at a time. And being a cop, I kind of did it one at a time. Hey, did you do that? The first thing they're going to say is, nah, it wasn't me. Even if it was them, it wasn't until you kind of went back around and talked to them more and kind of showed them some of the evidence and, or whatever evidence you had or didn't have or whatever, or until you kind of pressured them a little bit or guilted them, in my kids' way, that they would actually admit something. So it wouldn't be unheard of that suspects then would not typically admit their guilt right away, but it would take a lengthy interrogation before they would start to admit things. And then finally, number 3, successful police questioning requires sophisticated interrogation techniques that may be considered trickery or even manipulative in ordinary police interactions with the public. And I think it's important that you know that, because there are times where you need to use a little bit of trickery in order to get someone to confess to something. And a very, very quick example could be let's say it's a burglary case. And in this particular case, and I'll give you the story extremely fast, but here I was working for a police agency and there were a series of burglaries that were happening and we couldn't figure out who did it. I did receive a tip on the tip line of a possible suspect, but the person who called gave me no information, like their name, etc. So I ran the person as part of my investigation, and I was able to get a name, and this person lived in the area where the burglaries were happening. So what I did is I took my fingerprint and I placed it on a printout of their driver's license identification printout. And I went to the person's house and I knocked on the door and basically said, hey, I'm investigator so-and-so. I'm following up on these burglaries. I'm asking to see if you have any information that you could share. Have you seen anything, heard anything? And at first the person said really nothing. And then I showed them this piece of paper and basically said, hey, have you ever visited these businesses? And he said, no. I've never, and I reassured that he had never been there, and then I asked him why his fingerprint was found at the scene of a burglary in a place that he's never been. And so you can see this is kind of a mock-up that I made of what it looked like, and at the end of the day, the person confessed to me that he had broken into these buildings, and I recovered a bunch of property, etc. So is that trickery? Is that walking the fine line? Is that manipulative? I will let you decide, but let's kind of continue. And this is what I used, again, the information. So let's talk a little bit about confessions as we continue to go forward in some of this information. So again, let me just kind of back up here really quick and talk about a couple other things. Professor Inbau's arguments is nicely echoed, if you will, by Supreme Court Justice Antonin Scalia's remarks that even if I were to concede that an honest confession is a foolish mistake, I would welcome rather than reject it. A rule that foolish mistakes do not count would leave most offenders not only unconvicted, but undetected. So kind of an interesting thing. So it is often overlooked that in addition to speeding the conviction and punishment of the guilty, confessions can help exonerate the innocent without subjecting these individuals to the time and expense of a lengthy criminal investigation and trial. And there are also some practical considerations that the admission of, criminal guilt is an important step in somebody's acceptance and responsibility. But kind of finishing up on the confession part, there's really no reliable data that clearly establishes the percentage of cases in which interrogations play a central role in establishing a defendant's guilt. We can only note that jurors credit confessions with a great deal of importance in the determination of a defendant's guilt or innocence at a trial. So, talking about confessions, how are they or why are they important to the criminal justice system? So we know that confessions obviously play an important role in the process, but how? Or more importantly, why? Well, first of all, would be crime detection, because they help solve crimes in absence of that scientific evidence or witnesses, kind of like what we talked about on the dead body case, where you don't really have any information, and without the confession, we would be kind of stuck there. Number two would be a level of accountability, and acknowledging guilt is a step towards rehabilitation of an offender. And again, we're talking about the importance of confessions in the criminal justice process. And more importantly, and you don't have to agree with this, but it is true, confessions facilitate criminal convictions. So what that means is that they facilitate both criminal convictions of the guilty and also exonerate, or the exoneration of the innocent. So with that being said, though, do you think confessions present any type of potential challenges or problems in the criminal justice system? Well, just kind of backing up a little bit, and you talk about efficiency, it is estimated that the prosecution's case against O.J. Simpson cost the taxpayers, and this was back a while ago, over $9 million. And this number includes the cost of the district attorney, the assistant attorneys, the court costs, the judge, court reporter, assistants, the sequestering of the jury, meaning the putting away or separating of the jury while they decide a verdict, the sheriff's deputies that provided security, and let's not forget Mr. Simpson's incarceration for approximately 473 days. So, again, confessions, do they present potential challenges in the criminal justice system? Well, the answer is they can and they do. And the first challenge would be that of abuse. The police may be tempted to employ physical abuse or psychological coercion to extract a confession. And abusive conduct is encouraged by the practice of incommunicado police interrogations, the carrying out of interrogations in police stations without the presence of defense lawyers or some type of supervision. So, so just to let you know, it doesn't happen that often, but to say it never happened would not be a true statement. So are there ways that, there can be some coercion? Absolutely. So this is one of the potential challenges. Another challenge would be fair procedure, a reliance on pretrial confessions to establish a suspect's guilt is contrary to the principle that guilt is to be established beyond a reasonable doubt through the adversarial process in a courtroom or in a trial, if you will. The next one could be reliability. There is a danger that a conviction will be based on a false confession. And if you don't think there's something called a false confession, you are sadly mistaken, because there are several cases in which individuals have falsely confessed about committing a crime. And then inequality, because disadvantaged suspects lacking in self-confidence may be more vulnerable to trickery or manipulation. In addition, those who are extremely wealthy may have an advantage. And, they're more likely to be able, of course, to afford their own attorney. So, again, potential challenges. And I just threw these photos in just for optics, if you will. But it's important to understand that the threat of false confessions and convictions has been a concern for quite a long time. And because of that, this calls into question the adequacy of the protections that are made available to defendants in the criminal justice process, and is pointed to a lot of times by critics as illustrating the lack of fairness in the criminal justice system. So again, understand how that kind of falls into place. Now, we don't have time to watch these videos, but I have a couple of example videos if you want to take the time. The first one deals with Miranda and kids. The next video is one where an individual's rights are violated in an interrogation. And then the final one is a video regarding a false confession. So important videos if you want to add a little bit of context to this. So again, individuals isolated in interrogation rooms have been known to make false confessions, even in instances in which the police did not really pressure or manipulate the person, and treated suspects in a balanced and respectful fashion. So a couple of quick examples of this. So one interesting example would be the Norfolk 4. And I don't have time to go through all of these different cases, but if you have a chance, I have a video that talks about the Norfolk 4 and what happened in their particular situation. Another great case study is the Central Park rapist. So this case was back in 1989, where a 28-year-old jogger was viciously attacked and raped in Central Park in New York City, and 5 African American and Latino teenagers ranging in age from 14 to 16, who had been arrested for muggings and robberies in the park that night, confessed, and the following year were convicted in 2 separate trials. And 4 of the 5 actually made videotaped statements with parents or relatives present. So my thing is, if you didn't do it, why would you confess? So this shows you, oh, and by the way, they didn't do it. So again, it's important that we understand that. And typical was one young man's description that, Raymond had her arm and Steve had her legs, etc. And Anton did this and so-and-so did that. And a second person said that I grabbed one arm and somebody else grabbed this. But yet, here's the deal. They didn't do it. The young men claimed in court later that they had been pressured into the confessions. And the jurors at 2 trials, nevertheless, convicted them, because remember, confessions weigh heavy in a trial, and I hope that makes sense. And the massive publicity surrounding this case may have influenced the jurors to overlook a lot of the inconsistencies in each one of the defendant's accounts, and to disregard the fact that only a few hairs on one of the defendants linked the juveniles to the rape. Because in 2002, Matias Reyes, who was serving over 30 years for murder and 4 rapes, confessed to the Central Park rape. Oh, and by the way, his DNA was found to match that of the suspect. So what a fabulous case study. Not what happened, but a chance for us to look at and really understand that sometimes people do admit to things that they just didn't do. And when they went back and kind of looked at this case, a number of factors in this case combined to create a danger of false confession. So let's look at a couple of those factors before we move on to the frequency of these false confessions. But here are some contributing factors in the Central Park case. First would be police bias. Because the police were under an extreme amount of pressure to solve the crime and quickly concluded that the suspects must be guilty and focused on obtaining the confessions. Next would be age and intelligence. Several of the young suspects may have been tricked into confessing. 2 had IQs below 90 and may have actually failed to understand the meaning of what a confession is. Next were misleading remarks. Some of the young men claimed that they had been told that they would be permitted to go home if they just confessed. And one suspect reportedly was told that his fingerprints had been found at the crime scene. Another was informed that the others had basically ratted him out. And others were told that hairs linked one of the young men to the crime. So we have to really understand the dynamics of the level of misleading information and what that could cause. And then finally, the lengthy interrogation, because the young men confessed after being interrogated for more than 28 hours. Now, yes, most individuals won't confess right away, and it takes a level or a time to get them to confess. But I think we can all agree that 28 hours is a bit much, right? So here are some, again, contributing factors to the Central Park case. So how often then does this really happen? Well, honestly, I mean, nationally, the number is very, very low. So while that number is low, one examination by the Police Accountability Task Force of arrest, specifically in Chicago in 2014 and 2015, found that less than 1% of all arrestees, both adult and juvenile, had the assistance of a lawyer at any point during an interrogation. Now think about what I just said. That means a lot of people didn't have the assistance of a lawyer, because if they did, what might the lawyer have told them to do? Maybe not say anything, right? Maybe not confess to something until the attorney and the client actually spoke. So again, and in your textbook, there's information on false confessions by Professors Steve Dreisen and Richard Leo. And they documented 125 proven false confessions between 1971 and 2002. Now, the good news is that the criminal justice system responded by detecting 2/3 of these prior to trial. But on the other hand, 44 of the defendants were sentenced to at least 10 years in prison, and 9 of these defendants were sentenced to death. Now, this is not an overwhelming number of false convictions, but realistically, isn't a small number too many anyway? And we'll take a look at the reason for maybe some of those. So again, false confessions are a very small percentage of all of the confessions obtained by police. And these confessions, however, may result in the conviction of innocent people and really undermine the entire criminal justice system. So, with that being said, let's look at what psychologists tell us are 3 types of false confessors, because we've got some data on that. We can look at it. So the first one would be what is known as the voluntary false confessor. And this is someone who has the desire for publicity. They want to be part of something. Or perhaps they feel guilty for maybe a past crime and they want to make up for it. Or even the fact that they might be mentally challenged. These are voluntary false confessors. And the next one would be what we call, or what they call, a compliant false confessor. And this is an individual who confess in order to obtain a benefit, such as the avoidance of, it could be mistreatment, or to receive favorable consideration at sentencing. And this may range from a lighter sentence to imprisonment in an institution nearby to an offender's family. So you're going to get something out of it. So that's the compliant false confessor. And then finally, what is known as the internalized false confessor. And these are suspects that accept the police version of the facts, or might even fail a lie detector test, and at some point come to think or believe that they may have actually committed the crime. So again, these are different types of confessors that psychologists tell us that are out there. So let's look at a very interesting example of this. 18 years ago, Eddie Joe Lloyd confessed in horrific detail to the rape and murder of a 16-year-old Michelle Jackson, solving a case that had terrified the city after a wave of fatal child abductions in the area. And Mr. Lloyd's account in a 6-page statement and an audio tape was chillingly accurate. It was like almost right on, and it actually described the Gloria Vanderbilt jeans that the victim was wearing, and the half-moon earrings, and the red-handled knife that was used to threaten her, and the long johns, the underwear that were used to strangle her, the dirty green bottle that was left inside her. And really the only false thing about the confession was the confession itself, because he didn't do it. See, Eddie Joe Lloyd, back in 1984, was a resident of a mental institution. And he had contacted police about how to solve the rape and murder of a 16-year-old girl. And police were somewhat convinced that it was him. And they persuaded Eddie, who was taking medication at the time, to confess, because this would actually lead the real killer to relax or put his guard down. And that would lead to the killer making a mistake and then maybe possibly a chance for them to arrest the killer. They even fed Eddie some information to make the case stronger. Now, Lloyd was pardoned 17 years later when a DNA test indicated that he could not have been responsible for the crime. So let that sink in. Now, I don't want you to think that every case is like this. They're very, very few and far, between. But at the end of the day, they do happen. And, we have to be understanding about that, or at least knowledgeable about that. So let's move on. So let's talk a little bit about limitations on police interrogations. So the judiciary has relied on 3 constitutional provisions to ensure that confessions are fair. The 14th Amendment, which talks about due process. The 5th Amendment, which talks about self-incrimination. And the 6th Amendment, which of course talks about right to counsel. And there's some information that is listed in your textbook where we can talk a little bit more about that. And I can give you a little bit more about due process. So in 1884, the U.S. Supreme Court adopted the English rule and announced that as a matter of law, evidence, confessions, were inadmissible in federal courts if obtained by police tactics that were what they call sufficiently coercive. Between 1936 and 1966, the U.S. Supreme Court held over 30 confessions obtained by state and local police unconstitutional and inadmissible at trial under the 14th Amendment due process voluntariness test. And we'll look at a couple examples of those, the voluntariness test in a little bit, but I wanted to cover a few cases that talk about due process. And one would be, a case example would be Beecher versus Alabama. This is in 1967. That talks about the 3rd degree by police in order to extract confessions. And that's on page 265. Another case being Brown versus Mississippi, 1936 case, which talks about physical coercion. And that's on page 266. And then finally you have Ashcraft versus Tennessee, a 1944 case that talks about psychological coercion. And that's on page 266. So again, remember, the 14th Amendment, just to kind of clarify all that, as we have seen, there is a danger that the pressures of an interrogation process may lead to false confessions. The poor, the uneducated, and the mentally challenged are particularly vulnerable to things like trickery or manipulation. And former Supreme Court Justice Arthur Goldberg observed that history teaches us that a system of criminal law enforcement which comes to depend on the confession will, in the long run, be less reliable and more subject to abuses than a system which depends on intrinsic evidence independently secured through skillful investigation. The 5th Amendment, Herbert Packer in 1968 notes that in the American accusatorial system of criminal procedure, the burden is on the prosecution to establish guilt beyond a reasonable doubt at trial, and the defendant may not be compelled to testify against him or herself. And this is distinguished from a inquisitorial type system of criminal procedure in which the defendant does not enjoy the privilege against self-incrimination and must answer questions posed by the judge who typically interrogates witnesses. And then finally, in 1966, in staying with the Fifth Amendment, in Miranda versus Arizona, the Supreme Court concluded that the inherently coercive environment of what we call incommunicado or singular or one-person interrogations of individuals can overwhelm a person's ability to assert their right against self-incrimination. And then finally, the Sixth Amendment. So the U.S. Supreme Court supplemented the Miranda judgment in a series of cases that held that once the government has taken formal steps to prosecute an individual, he or she possesses a Sixth Amendment right to counsel. At this point, it is clear that the government is determined to prosecute, and the Supreme Court ruled that the police are prohibited by the Sixth Amendment from circumventing the trial process and establishing a suspect's guilt through extrajudicial interrogation. So, when you look back, when we talked about here the 14th Amendment, the Fifth Amendment, and the Sixth Amendment, those are some important pieces. And then, of course, these are important cases to note, example cases, again, that talk about where you can't use the third degree, if you will, to extract a confession, or physical coercion, or even psychological coercion. And the reason for that is because the Supreme Court asserts the aim of the voluntariness test is not only to exclude false convictions, but to ensure fundamental fairness in obtaining confessions. So, and that's really an important factor for us to remember. So let's kind of take a look at maybe what fundamental fairness actually is. It's the meaning, the methods used cannot be contrary to the criminal justice system. And that totally makes sense, right? Okay, so continuing with under the umbrella of fundamental fairness would be the fact that the Supreme Court asserts the aim of the voluntariness test, again, is not only to exclude false convictions, but to ensure fundamental fairness in obtaining confessions. And again, that means that police methods, that they must obey the law while enforcing it. And there's a case there, Spano versus New York, which is something that really talks about the fact that, again, that the police methods test is based on deep-rooted feeling that the police must also obey the law while enforcing the law. And in the end, life and liberty can be as much endangered from illegal methods to convict those thought to be criminals as from the actual criminals themselves. And that's the Spano versus New York case. So an extremely important case for us to know. But what about and we're staying with fundamental fairness, but we're going to look a little bit more specific at involuntary confessions. So, and it kind of starts as we look here. Again, we've gone through the fundamental fairness, talking about police methods, and now involuntary confessions. So, involuntary confessions, if you look at the Townsend versus Sane case. So, one of the purposes behind the due process approach is the exclusion of involuntary confessions that result from mental disabilities of drugs administered by the police and are not the product of what we would call a rational intellect or free will. In the Townsend versus Sane case, the defendant was arrested in connection with a robbery and murder. And the 19-year-old suspect had been addicted to narcotics since age 15 and was under the influence of heroin at the time of his arrest. And the suspect complained that during his interrogation, he was suffering from withdrawals and asked for a dose of narcotics. And in doing so, a doctor injected the suspect with a combination of phenobarbital and histidine, and this alleviated his symptoms, and then he agreed to talk with police, and he confessed within 25 minutes and also signed a statement the next day. So what do you think about that particular case? Giving somebody narcotics and something like that. So, I mean, following this individual, so afterwards he was convicted, and it was revealed that the police were unaware that one of these types of drugs was kind of a truth serum. So there's always something kind of cool in these cases. And the combination of the drugs that were given to him adversely affected his ability to think clearly. So the U.S. Supreme Court ruled that it is difficult to imagine a situation in which a confession would be less the product of free intellect, less voluntary, than when brought about by a drug having the effect of a truth serum. This was, again, we're talking about, involuntary confession. So this was found to be involuntary. Okay, so we're coming up on about the halfway mark. So I'm going to pause right here for part 1, and we will come back momentarily for part 2 of our lecture on chapter 8, covering interrogations and confessions.